When you're lost in a world of legal war, you don't know which way to go. There's a hero waiting with expertise to lend. The Utah employment lawyer, HR's best friend.
Welcome back to HR's Best Friend, our podcast for HR professionals and business leaders who want to make sure they stay compliant and don't get in trouble and keep their employees happy. Scott Crook is the Utah employment lawyer. He's consistently listed in Rocky Mountain Super Lawyers and Best Lawyers in America. He is the managing partner of Crook Legal Group. Scott is only licensed to practice law in Utah and Idaho. He is not giving specific legal advice. This shouldn't be construed as legal advice for your problem. If you need specific legal advice, please go to an attorney, preferably this attorney. All right, thank you. We are back. We just recorded an episode where we talked about a discrimination case that a black Muslim employee of a moving company went through, and it's pretty interesting. A lot of good tidbits in there to make sure that you avoid discrimination in your workplace. And then we also answer some anonymous questions that we found on Facebook and Reddit from HR professionals. Also, if you missed it, make sure you listen to the episode we did previously. That was a seminar we converted into an episode where my father and Carolyn Howe, one of our associates, dove deep into the Utah legislative session, and all of the laws that impact employers from that. So make sure you listen to that. All right. Thank you, and enjoy the show. All right. Welcome back to HR's Best Friend. Hello, Dad. It's been a while since we've both done this. How are you doing?
I'm doing well. And how are you?
Oh, I am great. We the last podcast we did, we turned the hour plus seminar on the Utah legislative session into an episode, and that's out there and should be required listening for any HR professionals in Utah, especially if they're working for governmental entities or anything like that, because there were a lot of laws that impacted them. So
that tends to happen a lot. The legislature will change laws that impact public entities much more frequently than they do for private employers.
Which is interesting. I guess it's easier for them to change those laws. Maybe they get less pushback.
That would be true. And I think also, in some senses, they use them as laboratories in some
right. Right. That's just funny. All right. Well, today we've got a couple of things to do. So we're going to do some illegal, actionable, immoral, or normal with a case, a discrimination case against a black Muslim employee, which is interesting. And then we have some anonymous questions. So we're getting back into our regular groove. We're also adding a producer to the mix, so it makes it easier to turn these around more quickly. So here we go. We're back. So let's do this. So there was a case in Georgia, and again, we're looking at this through a Utah lens and pretending it all happened in Utah, where a black Muslim employee of a moving company called All Star Moving filed a lawsuit for discrimination because he was Muslim and black. And so I'm going to read you some of these incidents, and you will give us your legal opinion on the illegality, actionability, immoral nature, or normal nature, and or of these different incidents. So this first one is that the management of All Star Moving regularly used the N word. So what about that?
Yeah, that's gonna, for the most part, that will tend to obviously create a hostile work environment. There are cases out there though, and this is true everywhere, that occasionally if someone does use the N word, as long as it's not, um, if it's stray employees occasionally doing it, then the court isn't going to find that as hostile. But if it's a frequent occurrence, or if it's a part of uh, other activity that could be discriminatory, the court's going to really hammer an employer for doing that, because clearly that could create a hostile work environment.
Okay, well, there we go. Now here's another one. The company routinely assigned its white employees to preferential jobs, which led to greater compensation and/or tips.
Well, if again, assuming the allegations are true, if that's true, that's clearly illegal, because if they are preferring one group of employees because of their racial characteristics over another, then that will be discriminatory. And so, if it's true that they were doing that, then that of course is discriminatory.
And spoiler alert, the judge did rule in favor of the person filing the suit. So it seems like most of this is probably true, unfortunately, and it gets crazier. Okay. And then this is similar to the other one, but All Star Moving compensated its white movers between 1 to 4 more than its black employees.
1 to 4 times more?
Uh-huh.
Well, clearly that's discriminatory. I mean, you just can't do that.
Okay.
It's so interesting to me, because there are people in the world who think, well, people won't be that blatant in what they're doing, but there are people who do act in that way, and they're obviously the people that the statutes are made to go
Protect
out.
the world against.
Yeah, yeah.
All right. Okay, and then this is where, so that was the racial piece of this. It turns I'm kind of weirder. So Lowe's coworker was Lowe is the person who filed the suit. So Lowe's coworker, who was a team lead, so a manager, asked Lowe if he identified as a Muslim after he observed Lowe greet another person using a traditional Muslim greeting. Lowe confirmed that he was. He had not disclosed this previously for obvious reasons. So he disclosed that. So after that, so here's the next bullet point, the specific instance that I want you to weigh in on. So after that, he heard All Star Moving's owner, so the owner of All Star Moving, whose name is Cooey. So he heard Cooey making several negative comments about Islam every week. Is that specifically something that's actionable, illegal, immoral, or normal?
Well, we can talk about the immoral, and I mean, speaking about somebody's religion in a derogatory way, of course, is not something you want to do, or you want your supervisors to do, and particularly if you're an owner, you don't want to do it. It is also illegal if it creates a hostile work environment. Now, there is some, and you do have to talk about this. There's some subtlety to it, because if he's talking about, if he's talking about Islam generally, and he's going after Islamic employees or Muslim employees because of their religion, that's obviously a problem. If he's talking about, a particular types of activities associated with certain types of Muslims or whatever, perhaps you could argue that it's not, actionable, but it's just not something you want to do. Overgeneralizing anything obviously will create a hostile work environment for somebody. And
Okay.
and I can speak directly to that, being a member of a minority religion, growing up in the United States. I'm a member of the Church of Jesus Christ of Latter-day Saints. I live in Utah, where it is, of course, much more common here, and it is the predominant religion in this state. But I did not grow up here, and I lived for a long time outside of Utah, and there are lots of people who have misconceptions about what I believe. And it was not unusual for people to say things. And I'm presuming that I did particular things, or I believe particular things, which were not true. And those things happened at work. And for the most part, it wasn't hostile towards me. I wasn't having a supervisor say, well, I'm not going to give you work because because you're a Latter-day Saint. I'm not going to give you this assignment. And they weren't particularly derogatory. So you can have discussions about religion even when people have a misunderstanding about what you believe. The problem is when it becomes hostile and when it affects the environment. And some people don't want to talk about it. And some people, if people are making decisions based on your religion, then obviously that's going to be actionable.
Okay, well then let's lead into the next thing. The owner once attempted to convince Lo to convert to Christianity, and he made veiled threats about what would happen to Lo if he opted not to convert to his Christian beliefs.
And so this is where I think, the second part of that scenario is the problem, right?
Right.
Just having regular conversation at work about religion, suggesting that someone might want to check, learn more about your religion, that's not necessarily going to be a problem. The problem comes when, number one, the person who's doing it is a supervisor, has control over, certain aspects of your work. They have managerial authority over you. And then if there's an implicit or actual explicit threat, that there will be some consequence if you do not do what they say, then that crosses the line.
Okay. So the rest of these, and
well, and let me add this, because I think it's important to know. In Utah, for instance, we have a particular statute that applies that doesn't apply in other states, and that is people are allowed to freely discuss their religion so long as it's not against and their moral beliefs, as long as it's not it doesn't, as long as one, the employer allows any kind of speech like that. So if an employer's had a blanket rule, you can't talk about religion here, you can't talk about politics here, then you would not be able to do that because he's restricting, or the employer's restricting everybody. If they don't have that blanket rule, which most people don't, the second issue will be if it's something that violates the business purpose of the legitimate business purpose of the organization that you're working for. So an example might be if you work for, an organization whose purpose it is, like a nonprofit organization whose purpose it is to protect a woman's right to have an abortion. That's what their purpose is. And you start at work, you are saying my religious beliefs are that people should not have abortions, and you start conveying that to the people that are being served by the organization. That organization probably can't take action because it is against their legitimate business purpose. And the same is true, like if you work for the Republican party, and then you started saying, don't vote for Republicans, only vote for Democrats. they're going to be able to take action in that case.
Okay. Complicated.
It is, but generally most people don't have those specific of business purposes. So what that means
Right.
is generally if people talk about the religion in Utah, they're allowed to do that.
Right. Okay.
They just can't cross the line by making it, pressuring somebody or making it a condition of employment that they have to, let's say, convert or,
Right.
like announce their beliefs in order to work for you.
Okay. Okay. So the rest of the let me go to this next one. The owner referred to Lowe and other Muslims as terrorists.
Yeah, that's in the context of the whole thing, that creates
Right.
hostility, obviously. An
Uh,
occasional statement like that, though, just like with the racial epithet, if occasionally
Right.
that were to occur, that's probably not going to
Right.
rise to the level of an actionable claim. But in the context of everything else, certainly that increases the hostility.
So you don't need to weigh in on these next ones specifically, but let's just take them all together. So Cooey told Lowe that his religion was made up. Cooey said that all believers of Islam were like suicide bombers. Cooey would often refer to Lowe as Muhammad. So taking that together with the All-Star Moving's owner making several negative comments about Islam every week, the owner attempting to convince Lowe to convert to Christianity and making veiled threats about what would happen if he didn't, the owner, Cooey referring to Lowe and other Muslims as terrorists, and then those next three things all together.
Oh yeah, I mean that's a textbook case of what would be considered a hostile work environment, and it goes beyond hostility if there's actual consequence to it. In other words, hostility enough. If something's hostile enough, that can create a actionable claim. But if the next step, if you go to the next step, which is, well, we're actually not going to give you work, or we're going to pay you less because of, or we're going to demote you because you are Muslim, then that's a much easier case.
Right. So, okay, we've already established that there's plenty of illegal and actionable things happening, but wait, there's more. So, Cooey initiated a conversation where he insisted that the Quran promoted hate and the killing of innocent people. Lowe tried to correct those comments and brush them aside when he told Cooey in response that if Cooey could show him parts of the Quran that supported Cooey's statements, then Lowe would give up his entire paycheck. Cooey then doubled down, telling Lowe that an internet search would support his position. Cooey ultimately told Lowe, "I don't need your kind working for me, get the F out." But he didn't say F. So that specific instance, with that, I mean,
That
do you
is
need other?
actionable. That's exactly. I mean, that's taking tangible employment action. So, yes.
Right. Okay. Okay. And then I had a question about, here's this next piece. In the separation notice issued by the employer, All Star Moving explicitly stated that Lowe was terminated for disorderly conduct, that he had been argumentative and disrespectful, and that Lowe had made terroristic threats. So if All Star Moving says that and it's not true, and I mean, as an employer, like an employer is lying, and you can prove that they're lying in the separation notice. I mean, what are the consequences for?
Well, the interesting thing is this happens all the time, and the way that, and this is a sort of technical legal thing. When you're trying to prove a case of discrimination, most people aren't that blatant. They don't say, "Well, I'm firing you because you're Muslim," right? They usually say, "I'm firing you, but it's because you don't work hard enough," or something like that. And so there's a whole structure of that's been developed around discrimination cases in which an employee has to put forward evidence that in under the circumstance will support a claim that the reason that the person was, affected at their job was because of race or religion or whatever. And then an employer has to come forward with a reason that is not discriminatory for the termination. Once they do that, then an employee can put forward evidence that the claim is pretextual, that it really wasn't the basis. So in this case, this would be pretty easy to overcome that presumption, because you would just say, well, look, you told me to get out after I argued with you because I wouldn't agree to convert to Islam, right? So it was a pretext. And so there's a whole body of law that's built up around this very issue. The other interesting thing about it is generally an employer can let somebody go for a mistaken reason or even a false reason. I mean, they could claim, oh, I let him go because he didn't work hard, but it was really because you wore pink, shoelaces and you didn't happen to like pink shoelaces. Well, either one of those reasons is not particularly a good reason, but it's an okay reason. And the courts won't say, oh, I'm sorry, you've lied about the reason that you let him go, so therefore you can't let him go, right? The only time that that becomes important is for purpose of unemployment, for instance, if you're misstating the reason you let an employee go and therefore trying to avoid having to pay unemployment, or if it's actionable because you're actually trying to hide the fact that you're discriminated against somebody. So again, there's a whole
Which may be the case here.
Yeah, I mean, it's clearly what they were doing, and obviously,
Right.
well, and I could say that only because the judge already ruled that that's what happened. But
Right.
it's certainly if all of that is true, and if that's what the court found, then this is an easy case of discrimination. Much easier
Right.
than many cases.
So the last piece of this, which is cartoonish and it's crazy. So and I'm just, because now the employment has been terminated, right? And so this is an interesting little wrinkle. When picking up his final paycheck, Lowe was met with Cooey holding a baseball bat, striking it into the palm of his hand in an apparently threatening manner. And Cooey suggested that he would hit Lowe if he did not immediately leave the premises after getting his paycheck. So, he's no longer an employee. But is there any employment law analysis to do on that beyond this guy just being crazy?
Well, the fact is that of course can be considered retaliation. It can also be considered discrimination itself, because the reason why he's doing it is because of this underlying hatred of Muslims and apparently black people, right? So obviously that supports the claim for discrimination because it's evidence of it. But the other thing you have to remember, even if something's not actionable as strictly an employment law claim, is that, people, when they're working for other people, like supervisors can be sued, or owners can be sued for battery and assault and, intentional infliction of emotional distress and those sorts of things. And certainly somebody menacingly holding a baseball bat and telling somebody to leave probably constitutes assault, and you could probably sue that owner directly, personally, for that behavior.
So if you're a manager of a company, you can't beat up an employee and be saying, it's okay, I'm not liable, this is at work.
Yes, exactly. And in fact, most of the time, like for instance in Utah and under federal law, individuals don't have individual liability, even if they're the ones that discriminated. It's the company that has the liability.
Right.
There is no individual liability for discrimination. But if you cross the line and you hit somebody or you threaten them, then you can create individual liability because that is you personally doing something that would be actionable outside of the employment law context.
Okay.
It's never a good idea to threaten to hit somebody or to actually hit somebody. In fact, there's a very famous case in Utah that actually allowed, this is different in many respects, allowed an employee to recover for emotional distress in an employment setting for a breach of a contract because the supervisor was actually kicking and hitting the employee, and he was not, he was kicking and hitting them in, let's just say sensitive areas. And so the court there said normally in Utah you can't get emotional distress damages for a breach of a contract, but in Utah, because of this case, if the behavior is bad enough that would constitute a breach of an employment contract, you can get emotional distress damages, and that would be from something like that. I mean, it's hard to believe that somebody would act like that, but people do act like that.
Okay, well, there we go. So that wraps up our discussion on that. So now we've got a couple of anonymous questions to look at, which I thought were interesting. So this first one is, I received an email from HR. So this is someone that's, I guess, not technically HR, but this is something they received from HR, and I think it's interesting. I received an email from HR letting me know that I received a merit increase, but the caption read, personal and confidential. The following pay information is personal and confidential and should not be shared with other team members. Should you have any questions, please contact Human Resources. So this person's question was, isn't this illegal? If so, what does the employer do to fix this now? And how do you prevent this?
So the answer to that question is it depends, but that's a normal lawyer question. This surprises many people, okay? The National Labor Relations Board, which enforces the National Labor Relations Act, requires, I'll say it this way, prohibits employers from interfering with an employee's right to collectively bargain, which includes the right to discuss wages. So if that email went to an employee who is non-management, non-supervisory, then that is an illegal condition. You cannot tell employees who are not supervisors or not managers that they cannot discuss their compensation. That's illegal under the National Labor Relations Act. So I can't answer this question because I don't have enough information. If this person were, let's say, the general manager of the supply, the supply room at a car dealership, they were they managed it, then this would not be an illegal condition. However, if it were someone working for him, it would be.
Okay. Thank you. That's a good thing to know. There's a difference. All right, here's the next one. An employee has accused supervisor and other colleagues of discrimination multiple times, and each time it's been fully investigated and dismissed due to witnesses coming forward and correcting the story. Example, accusing supervisor of saying ABC, and then 5 other witnesses come forward and report, actually, he said XYZ. And here's the email recap he sent afterwards that reiterates it. Employee has filed EEOC complaints and gotten lawyers involved. Employee relations is on top of things, solid documentation and investigation. Absolutely no evidence of anything discriminatory. The entire team walks on eggshells around this employee due to fear of being confronted with a lawsuit or complaint, and they are miserable working around and with this person. If they say good morning to someone and not the employee, they complain. And if an employee cracks a stupid joke, not inappropriate, but like a cheesy pun, the employee complains about it, etc., etc. I don't have a background education in HR and work on the learning training side instead. So for my own education, what are the options with an employee like this? There is an EEOC complaint, so does that mean they are untouchable, for lack of a better word? What's the best practice here?
So that's a really loaded and complicated question to answer. But let's just start with um, the first thing that um, needs to be said, and that is that if an employee complains in good faith of discrimination, or participates in the investigation of a claim of discrimination, they are protected against retaliation. So, a person cannot be, action cannot be taken against a person when they actually are um, complaining legitimately about discrimination. So, does it make somebody like that untouchable? The answer is, well, I won't answer that yet. Does that mean that you can take action against somebody who lies, for instance? They come and they say, oh, well, you know, perfect example might be in a sexual harassment situation. A woman comes in and says, hey, this guy came on to me, you know, grabbed me and kissed me and or whatever. And they happen to have, the employer happens to have um, video of the hallway in which the person makes that claim. It's clear that none of that happened. It's a total lie. Can the employer take action? They certainly can, because they lying about a claim of discrimination is not in good faith. The problem arises in these types of situations. So the answer is no, they're not untouchable, right? But the problem lies in situations where people legitimately think they're being discriminated against, but they aren't. And maybe this person who is making all these complaints, has a heightened sensibility and thinks every slight against the person is discriminatory. Well, if they legitimately believe it, then they are protected. And this is a very, very difficult situation for an employer, because the employer doesn't want to be accused of going after the person because he makes a lot of complaints about being discriminated against, because that would be the exact reason why you can't let somebody go. However, if this person clearly is like a reasonable person in that employee's situation would not think it was discrimination, you probably could take some action. Now, as an employment lawyer, would I say you should take action, or if it's even close? No way, because there's a real chance you could have liability. Even if every time they complain, they say, well, no, it wasn't really discrimination, although we can see why you could have thought that. Now, the description also says that they know that he says ABC, but XYZ is actually what happened. That suggests maybe he's lying. In that circumstance, maybe you could take action. But these are difficult things. This happens all the time. What the scenario often happens where somebody comes in, is called in because they're having problems performing. Maybe they haven't been written up. They're not putting on a performance improvement plan, but in order to prevent or to try and protect themselves, then they might say, oh, well, I asked for an accommodation in that meeting for my disability and he didn't do anything, and said, well, I'm going to make it hard for you. Then that can forestall what could happen. And sometimes people do that they essentially do that in a preemptive manner, so that they can prevent further discipline from happening or performance improvement. So it's something that if an HR representative has not dealt with that at least once, they will. It will happen in every workplace, almost.
Well, that's too bad. That's complicated, but I guess it keeps us in business.
That is true. That is true.
Okay. That's complicated. Well, thank you for sharing your wisdom today. That wraps up our episode of HR's Best Friend. Thank you for listening, and we will see you next time.
Yeah. Thank you very much.
When you're lost in a world of legal woes, you don't know which way to go. There's a hero waiting with expertise to lend. The Utah employment lawyer, HR's best friend. Ooh yeah. He's the advocate of the office, the guardian of rights, fighting for justice in the darkest of nights. When you're caught in the HR maze, feeling all alone, he's the ally you need to make your troubles be gone. Oh, the Utah employment lawyer, HR's best friend. He's the